we want to have our loved ones to have some discretion because things develop between the kids. And if you create separate pots, you might find that their circumstances are such later on to where you wish that one would have more because of their legitimate needs.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by Tucker Allen. Here's attorney CPA Joe Cordell.
Welcome to another episode of Life's Third Act. Today we're going to do part 2 of the life, death, and estate of Kobe Bryant. So under this contract, Vanessa apparently didn't have the confidence that they were going to promote the brand and introduce styles that she thought would keep his name and legacy alive.
Yeah.
So she pulled back, and I don't know what ultimately happened. Did she sign with the...
So she hasn't signed with anybody else. Her biggest thing was that, like, when Kobe was alive, he introduced that retro style with new technology, and he made sure that it was accessible to all of his fans. And so the contract came up in 2021, and she found out they weren't going to do, like, child sizes anymore. They weren't going to do a lot that served his fans. And she pulled back because she was like, this isn't what he would have wanted. He wouldn't have wanted to serve his fans this way or anything. So they gave her new contract terms and she still didn't agree with them. She hasn't signed with anybody else. She said that she is looking for a way to make everything that has anything to do with him accessible to all of his fans. And I think just make sure that there's like a high number of quantities and it's not, some super rare value item or anything like that. So I haven't heard any announcements. I don't know if that means that she's going to form her own brand from the Kobe name or if she's going to sign with something else. I don't really think she'd sign anywhere else just because he's had that contract with Nike for so long. I think she would probably form his own brand and then kind of pull in like brands as needed. But not a whole lot on that front right now.
Yeah, Nike's losing some of their...
They have lost a lot.
Endorsements.
Yeah, they've lost a lot.
So,
and the state owns the Kobe logo, but there's a sheath logo on his shoes also that's co-owned by Nike and the Kobe estate or the Bryant estate. So yeah, when we talk about an estimated net value of $600 million, we can't be sure what all is included, whether that's based upon what was part of the estate. In other words, things that would go into probate. Was it an estimate based on what they think is inside the trust? Or could it be less tangible interest that he had in contracts, branding, name and likeness, other things that you couldn't assign a number to because we didn't know. If you didn't have existing contracts long-term, then you can't assign a value. So if you had a contract that was going to expire in, say, a year, so technically if you're an accountant assigning value, then you can't project that into the future, though as a practical matter, those contracts will be renewed. And a brand like Kobe Bryant, it's going to live. It's going to live for many decades. So one thing, again, this is consistent with this whole discussion here, is we're talking about what a great, responsible family man he was. So as early as 2012, he decides to do revised estate planning. Whatever he had in place, he revamped it completely. He created trusts and more sophisticated instruments so that he had one trust that was designed to take advantage of exemptions that you have when you have a lot of money. You have exemptions that are available, and those exemptions have gone up here in this century. So it's important to be sure that for tax purposes, that you be sure you take advantage of that. So he had 2 trusts set up, and in both trusts, the beneficiaries were his wife and his children. Now, the children that he named in 2012 would not have included Capri. And in fact, it wouldn't have included what? Bianka either. But appropriately, he revises it in 2017 because, why? He's had this child called Bianka. So being this fastidious,
responsible parent that he was, incredibly devoted, above all things, to his family. I guess above all things, specifically to his daughters. He made sure that he dotted I's and crossed T's, with the exception that, doubtlessly if he had lived another 5 or 6 months,
he would have done it.
He would have done a third revision to allow for Capri.
Yeah.
Capri, again, was 9 months old.
Everything you build for you and your family deserves protecting. All of those important assets you have worked so hard to acquire and enjoy, you want to make sure they're handled with care. At Tucker Allen, our attorneys will customize an estate plan that will work for you and your family's goals and needs. Tucker Allen, estate planning, probate, and trust administration. Visit tuckerallen.com.
In this case, of course, and this is one of the lessons for us, is you can never assume that I'll get it done, in the next year. We know historically he'd always gotten it done. He had gotten it done for his first daughter, second, third, and he would have this one. But that opportunity never came. So the trusts that were created in 12, I'll tell you what the terms are, because he continued those terms. Those same terms will apply to the revisions that occurred in 2017. And that was that he wanted to assure that his wife was taken care of. So his wife was a beneficiary. The daughters were beneficiaries in equal shares. And this was called a discretionary trust, meaning that he wanted asset protection. So he wanted to assure that, all these profiteers and others out there who might come after you in various ways, lawsuits, et cetera, would not have access to this trust, that it would be bulletproof. So he designed it that way. Yet there's enough flexibility to where the trustees, which were his wife and his business manager, the business manager's name was
Robert Plinka.
Yep. Jr. Robert Palinka Jr. So Robert Palinka had been with him a long time. He was much trusted, and we have no reason to believe he didn't fully deserve that trust. So there were co-trustees. Again, smart. It's the way you do it. It's better than simply have your wife have a co-trustee, and that does a couple things. It allows some expertise regarding things that his wife naturally, I suspect, did not have expertise in, business matters, some business matters. And at the same time, it's a check and balance on the judgment of the two. So it's nice to have two trustees with a division of labor between them. Not the identical roles, but a division of labor. He kept those in the next version, 2017, of this trust. So he sets up trustees, and those trustees have the discretion to kind of pay out on an as-needed basis. So it's terms such as health, education, maintenance, and support. It's a common phrase. The IRS recognizes it, but it says something. It says there is a standard, so it's not that a trustee is free to give it out in any way they choose, but it's loose enough to allow people you love and trust, the people you've put in the role of trustee to run your trust. It allows them to use their judgment. They're not hemmed in by technicalities that might result in litigation about whether a particular payment should be made. So it was a wonderful setup in many ways. Again, it was updated in 17, so he's covered the next daughter, but of course it was not updated for Capri. So he dies. The assets that were in the trust, this was probably a revocable trust. We don't know all these details because, as I've said many times on the show, one of the beauties of a trust is that it's confidential. You can't go snooping around and see all the family details and dirty laundry that are made public in a will, typically, especially when it's a will fight. So he could have made any change that he would have wanted to make in this trust up until his death. And that's common. Often people will have a revocable trust. Now it became unrevocable. It became irrevocable at the date of his death. So in his will, he had what I'm confident, I couldn't find a copy of this, but I'm confident the will had a provision that said, whatever assets are not in my trust now, these are to go into my trust, a pour-over will. We talked about this in one of the last two shows. So pour-over provision in a will is like a safety net. It's intended to catch stuff that you didn't already have in your trust. And sometimes there are reasons to not put things in your trust. However, cautionary point is if you don't put it in the trust, it goes into probate. Now, probate puts it in the trust. In other words, the beneficiary, rather than being, a wayward child, for example, the beneficiary is my trust, dated such and such date. So it does end up in the trust, but it takes a circuitous and a bit of a public pathway to get there, although the public doesn't see the contents of the trust in doing that. Now, the reason we know a little bit about the contents of the trust is because, in this case, the family had to file an action to get a judge to permit the trust to be amended. Now, I'm not going to talk about some esoteric points here that would be of interest to estate planners and to some minority of you, in which, I speculate about what would be the consequences if that action hadn't been brought and you have what's called an omitted child or a pretermitted child, that such statutes exist in virtually every state that are intended to deal with a situation where you have a child that wasn't included, kind of like this, for the same reasons, typically, is that you didn't get a chance to update it for an afterborn child. So that typically applies with respect to probate and wills. It does not universally apply to what are called testamentary equivalents, which are like trusts. So this child might have had a claim to anything that was coming through the will in a disproportionate share. We don't know all that. But the point is, everyone agreed. The mother, the other trustee, children, everyone agreed, we want this child, we want Capri to get an equal share and to fully enjoy the benefits of their father's estate just like the other children. So that's not easily done because remember, whenever you create a trust, one consolation you have leaving this world is that your intentions, as you have memorialized in this document, are pretty much in stone. You want that to be the case. You don't want this to be something to where your family might decide, gee, I like this provision, but I don't like, let's get rid of this provision. Let's add this. Oh, and in this case, why don't we add a beneficiary, a distant cousin in extreme, just making a point here. The idea that you could add a beneficiary is not something that the courts do lightly at all, even in these circumstances. So on the one hand, we want to praise the fact that you can have confidence your trust will be amended only with an abundance of caution and care and meeting certain standards. One of those standards is it cannot violate a material purpose. So if this had violated a material purpose of this trust, for example, if one of his children had been handicapped, and an older child had been handicapped, and that his primary purpose in setting up this trust was to allow a lavish portion to be available for that particular child, then that might be an example of a material purpose that would have been undermined by adding a child into the pool of benefits. So in this case, of course, there's not that, but there had to be a hearing, and so we got access to some of these documents and what their terms were. So in this case, though there was money spent, time consumed in getting this done, eventually the gavel went down in L.A. probate court, L.A. County, and this change was made. So Capri now will enjoy all the benefits of her siblings with this trust. A couple other comments about the estate plan here. One thing that I don't approve of is that Kobe had a provision in his trust, not uncommon, that when his children reached a certain age, that the assets will be distributed to them in full.
Oh, we don't like that.
No, we don't like that. These kids may have marvelous judgment. Even if they do have marvelous judgment, as we've talked before, it's just never a good idea. It can be so much more beneficial to the children if they get to continue having it in a bulletproof container, all their, the bulk of their wealth, and be able to reach in and get it out when they want it if they have a cooperative trustee. And this was set up to give them cooperative trustees. So originally, keep in mind that Kobe was the original trustee of his revocable trust. The successor trustees were the wife and the business manager, and there were successor trustees after them. So I disagree with the notion that when these children reached an age, which I don't know what the age was, but I know there was a provision in the trust for it to be distributed to them. Maybe it was age 30, maybe it was 40.
Yeah.
I just think there's never a point when you want to do that because you reduce the value.
Well, and if you're going to do it at 40, then why not just keep it going? Or 30 or 40, they're going to be used to it by then. Yeah,
and they have the best of all worlds. If they have a car accident and they get sued for $100 million, this container's bulletproof. Mm-hmm. But if they want to withdraw money for a reasonable purpose, a cooperative trustee is going to give them the money. It's the best of all worlds. You can't create that world for yourself. You can't take the money. If your parents had given you, say, $30 million, you couldn't say, I want to create a bulletproof container for my $30 million. The law, you can do some things in some states, but you can see why courts and legislators are reluctant to do that.
Yeah.
Whereas if somebody else has given you something with conditions, then that doesn't smell anymore of you're trying to be squirrely, in avoiding legitimate creditors.
Mm-hmm.
So it's hard for us to create it for ourselves. We can to some extent with a lot of limitations and qualifications. Whereas in this case, when somebody else gives it to you, it's not your doing.
Yeah.
And so courts are comfortable enforcing those provisions. A couple other things about this is I'm wondering to what extent there are assets that will have to be managed over time, and we can expect them to bring in professionals in addition to this business manager to sort of manage these trusts.
Yeah.
I think that, we've praised Kobe a lot here. Well, I'm going to add another dimension that we've not talked about. He was an incredibly good businessman. Mm-hmm. In matter of fact, in an interview that he gave, he talked about the fact that, his legacy, while he certainly values basketball and of course his children, but beyond just his children, all children, he felt that the greatest contribution he hopes to have, believe it or not, is as an investor. And it's kind of an interesting perspective. His perspective is based on the idea that he said in this interview, and I think it was a ESPN interview, he said, I can accomplish more for more people for a longer period of time by way of investing wisely and then having the capability of creating programs such as what he created there, his basketball program that existed in L.A. County. So he was a fan of using wealth in a way to create good, mainly for younger kids, over many decades, far more than he could accomplish simply as a role model as a basketball player. And I thought that was a very astute observation. So he invested very wisely. Believe it or not, he had some very sophisticated investments. For example, he launched a $100 million venture fund called Bryant Stibble, which he owned at the time of his death. And at the time of his death, had a total capital valued at $2 billion. And it invested in various forms of technology, some media industry investments, but it was a very forward-thinking innovation fund that had done very well. Now, I don't know that was included in the estimate of these assets, but I suspect that it was, the value of his interest in that fund. But who knows what the value of that fund would be today? It is today. We don't know if they continue to hold those investments. He was somebody who regarded it as his responsibility to accumulate wealth with the intention of making it available to various charitable organizations, et cetera, and which he did a lot of. So one thing is clear is that running these enterprises, unless the interests are liquidated, running these enterprises will require additional professionals, which is a theme we see over and over when we talk about figures such as this, whether it's sports or music or entertainment. And we know that his branding and his intellectual property, as it's called, will continue to generate funds for years to come. So I only expect this number. If the $600 million is complete, and I suspect it's significantly more, we have every reason to believe that by the time this trust is distributed, that it will be substantially more.
Yeah, I agree. I think it'll be a lot more. And I think that I have a belief that eventually the girls will like join that crew of people who, work on protecting that and everything like that. But I think it is interesting that they haven't set up any type of like foundation or anything yet.
Yeah, and I don't know. I don't know if they have or not. I mean, he had several charitable entities that he had formed, like the was it the Mamba?
Yeah. The Mamba Sports Association was that one, and then he had all of that. He had a couple other ones that weren't as big. Yeah.
So one other point that I'll make is that he had a condition on the wife's interest. What wasn't consumed, given these constraints, which albeit are not firm, but they're soft constraints, and they are constraints. But given those levels of control, which is what is very common for people who leave money to both their spouse and their children, they'll often do it in the form of two trusts, like sometimes called an A-B trust, a bypass trust. But these are trusts to allow to take advantage of tax benefits and at the same time giving the wife access, the surviving spouse, often the wife. Statistically, it's the wife. Guys, I'm sorry to tell you, but whatever you make in this world, your wife will probably spend it. But So whoever survives, husband or wife, the distribution of that money is loosely governed by the trust, so that the surviving spouse can meet his or her reasonable needs, and yet at the end they have what's called a limited power of appointment. So whatever is not consumed, and it's presumed that it will not be entirely consumed, given these restrictions I described. That money will be appointed, they'll have what's called a limited power of appointment to one of several people, but it cannot include their estate or their creditors or people other than those specifically prescribed. So in this case, it's these two, now three surviving children that the wife will have an option as to her trust. It breaks into two pieces. As to her portion, she'll be able to, she can discriminate if she chooses, which I think is kind of, we want to have our loved ones, our spouse, surviving spouse, to have some discretion because things develop between the kids. And if you create separate pots, you might find that their circumstances are such later on to where you wish that one would have more because of their legitimate needs. So what's nice about giving, breaking off a piece for the spouse alone to have a limited power of appointment over is that whatever's left there, she will make that decision, but she can't choose a beneficiary other than those that are listed. So it's something he added it's not unusual, but again, it reflects, good judgment, good planning. My single largest criticism here is that, when you have big changes in life, you've got to get in to get them corrected. This was correctable, but a lot of things are not, depending on what the development is. If somebody becomes disabled, if financial circumstances change in a dramatic way, you may want to change dramatically your distribution plan. So there's just, blows or developments in life that it's imperative that you get in fairly short order to update your estate planning. So all in all, I guess we have to say of Kobe that he planned his life well and he planned his death well, given the minor criticisms that we've had.
Yeah.
So anyway, this has been another episode of Life's Third Act. I hope you found this both interesting and informative. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement. Sponsored by Tucker Allen, your estate and elder law advisors. Each week we discuss topics and answer questions to help you better plan for your future. For more information, visit tuckerallen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.